I hope you can hear me. I'm starting this presentation with a special reference, I would say, of a temporal character. First one is related directly to Lena. As years go by, we normally tend, whether we want it or not, to be less open, and it becomes more and more difficult to become real friends with someone. We are set in our ways, we are less emotionally available, and Lena, for me, was a special person in the sense that I managed, thanks to her qualities, to regard her as my real friend and to feel the warmth and involvement that at my age it is not so easy to feel towards someone new in your life. And I'm very grateful to her for that. Second temporal reference would be to the fact that I have started to work at the Registry of the European Court of Human Rights 20 years ago as a relatively young lawyer then. And let me tell you that 20 years ago, someone who would use the term reproductive rights in the register of the court would be laughed out of the job. This was something which simply, A, did not exist, B, was not known, third, was considered as something freakish, I would say. So we have come a long way since then, and I will try to give you a brief account what has happened since 1993, when I started to work. So I divided my presentation into 3 parts: achievements, challenges, and prospects. I will spare you the basic presentation of the court's case law regarding health issues and reproductive rights issues on the assumption that more or less we are aware what has been done. However, to recapitulate, here are the fundamental reproductive rights and health cases of the existence of which we should all be aware. You will find them in the court databases. First one is the Voix against France, July 2004. Then we have Draon against France, much maligned and much discussed Tysiąc against Poland, Evans against UK, Dixon against the UK, ABC about Ireland. There is one fact to which I would like to draw your attention, which shows to what extent reproductive rights do now have legal existence, is that on the court website, the court started to put some time ago, within the framework of the information campaign, so-called facts sheets, which essentially amount to a number of very short extracts of fundamental cases in special areas. Only a couple of years ago, we're finding their basic stuff like right to life, right to personal liberty, right to the protection of private and family life. And lo and behold, we have now there available since 2010, roughly, a fact sheet on reproductive rights. So for those of you who are not very familiar with what the court does, this is a first stepping stone on your legal journey to knowing what the reproductive rights under the court case law is all about. On the footsteps of those basic judgments I have mentioned, we should say a word or two about the recent developments in reproductive rights. ABC against Ireland, in which the court was dealing with Article 3 and 8, namely with issues arising with regards to no access to legal abortion in Ireland, and it examined whether this could amount to a breach of Article 3 essentially and 8 of the Convention, prohibition of inhuman or degrading treatment and protection of personal and family life. RR against Poland, which was following in the footsteps of Tysiąc against Poland. As you might remember, in Tysiąc the issue was concerned the difficulties in practical access to lawful abortion, or rather legal abortion under Polish law to a woman who was very severely short-sighted. Here we have practical difficulties in access to prenatal genetic tests. Then we had a long saga of 2 cases, the cases SH and others against Austria, concerning the limits on the legal availability of heterologous techniques of medically assisted procreation. Then we had 4 cases, started with the VCC against Slovakia and a number of others concerning unwanted sterilization of Roma women carried out in Slovakia in the early 90s within the framework of sort of misconceived eugenics or social policy. So those are the judgments which are quite important and interesting. Then we have a much less known case of Ternovsky against Hungary. And in this case, we had a woman of reproductive age who was complaining that under Hungarian law, it was impossible for her, precisely because it was unlawful to have a home birth, in which case the court found, surprisingly enough, a violation of Article 8 to the Convention regarding respect for private life. We have a recent case of Z against Poland, arising under Article 2 concerning death of a ill and pregnant woman of 28 or 29 years who died. She came to the court alleging that the medical treatment she received was inadequate because the doctors were too much concerned with saving the baby and not enough concerned with saving her. She died and her mother brought the case to Strasbourg. Then we had a case of PNS against Poland concerning Articles 3, 5, and 8. And we have a teenage unwanted pregnancy, again, practical difficulties with access to legal abortion and deprivation of liberty to prevent abortion. Then we had a very recent case, a decision was given last year, of Daniela Knecht against Romania, with of very particular circumstances. We had a woman approaching 40. She had one baby to whom she has given birth by way of in vitro fertilization, and then she had a number of embryos who at the same time were created and stored in a private clinic. There was a raid of the prosecutorial authorities on this clinic. The clinic was closed because apparently it was operating without necessary authorization. The embryos were put into the storage of the National Institute for Transplant, and then she had considerable difficulties for quite a long time in getting those embryos back. And the state authorities were blaming each other for the fact that she could not obtain access to them, to her own genetic material, so to say. And then we had a very interesting case of last year, August last year, concerning again Article 8, Costa and Pavan against Italy. We had a couple of persons, healthy couple, who were carriers of cystic fibrosis. They had already one child who was affected with cystic fibrosis. They didn't want to have another one. She got pregnant. It turned out that during pregnancy, that the fetus was affected with the same condition, but she had the test carried abroad. The problem in this case was that it was legally impossible in Italy to have pre-implantation testing of the fetus. In other words, you could get pregnant, you could have tests already being pregnant, and you could abort it if it turned out that the baby was affected. But on the other hand, you could not have a pre-implantation test of the embryo before becoming pregnant. So she came to Strasbourg and she She won the case because the court found that the Italian regulation was not reasonable enough. Then we have a very interesting case which has nothing to do with reproductive rights, but it's very interesting to all people who are dealing with medical law issues. It is Christosov against others, against Bulgaria. A number of terminally ill cancer patients came to the court and they were complaining about lack of access on so-called compassionate grounds to medicaments which they thought could be possibly either life-saving or life-prolonging. Whereas under Bulgarian law, there was law which was saying very clearly that there can be no access whatsoever to medicaments which are not officially allowed to be used and circulated in Bulgaria, whereas in many other countries, such access on compassionate grounds is possible. We will, as to currently pending cases, we have a quite publicized case of Gereb against Hungary. This is it has been brought by midwife who was specializing in, as I said, unlawful home births, and she has been arrested, and there are criminal proceedings pending against her. We have a Polish case about procedural obligations of the state concerning, brought by a husband and mother of a woman who died in childbirth. We have a case which follows in the footsteps of those Slovak cases, Get Out against Poland, of a woman who was sterilized as a result of medical treatment. The problem was that no one ever told her that the operation she's going to have will result in sterilization. So this case is mostly about informed consent and what kind of consent the patient should be able to give in order for it to be really informed, and what are the obligations of the medical community in this respect. We have this Mierzewska against Romania, which is pending again. It was communicated, it was very similar to Knecht against Romania. And we have this Azeri case, which is quite similar to Get Out. As to achievements, I would say that generally, we have heard time and again, since the judgment of ECHR against Ireland about legal aid back in the 70s, the court said that the convention guarantees rights which are not theoretical and illusory, but practical and effective. And this is the approach which the court applies also to the reproductive rights. We have the notion of positive obligations of the states, which are very well entrenched in the court's approach, and it is also transposed to reproductive rights. What is to be noted generally is that the court is quite activist as regards the scope of the state's positive obligations in many areas, not only reproductive rights. Namely, the court says that it is not enough for the state to abstain from doing something, but the state should take practical measures, not only legal measures, but practical administrative measures in many areas in order to secure effective enjoyment of rights. The court also has read during the last years a number of, I would say, technically speaking, socio-economic rights into the classical rights which are protected by the convention. As I said, the notion of reproductive rights found its way for good now into the court's glossary of legal terms. I have mentioned already this fact sheet on reproductive rights. As to the achievements, the next thing would be that the quality of medical care is often very central for the outcome of the case before the court, even though if you read the convention on its protocols, you will be well aware that there is no such thing as right to medical care or right to health, but still the court does it quite often. There is a novelty in VC against Slovakia in this, that the court for the first time ever criticized paternalistic approach in medical care, which it never did before. We have to note that the circumstances of the case were very special. We had Roma women which were sterilized because the doctors and the medical institutions thought that they knew better what is good for them. But so we cannot be really sure whether this same criticism of paternalistic approach would be also transposed to, so to say, normal medical care cases, but at least some door has been open. The court has been, in recent years, very strongly stressing the respect for individual moral autonomy in cases concerning medical care, life and the death issues, and reproductive rights as well. Much stress has been put in medical cases on importance of informed consent in medical care, and on the state's positive obligation, on the doctors and medical institutions' positive obligations to make sure that the person really understands what is going to happen, what are going to be consequences, what are the therapeutic choices and consequences of those choices, which I think in Central and Eastern Europe is a serious problem, in Poland included. Then to achievements on. The court put great stress on the practical availability of abortion. It was a central concern for the court in the Polish cases raising this issue. And also the court went quite far in order to protect so-called dissenters in medical community, doctors who, for one reason or another, were concerned about the interest of the patients and who dared to speak or to dare to question clinical or therapeutical judgments or decisions made by their colleagues, to which the Polish medical community has had so far rather a severe approach. And the court said that you cannot, being a doctor, you cannot be punished if you have your patient's interest at heart and if you criticize other doctors for this. So there has been a number of cases concerning this. Frankowicz against Poland, Sosinowska against Poland, and now, I'm sorry, it was Gereb against Hungary. We should also note the unprecedented step of applying Rule 39 in the context of reproductive rights cases. In Knecht against Romania, immediately after the case came to the court wrote to the Romanian authorities and said, listen, we have this case pending before us, so before the opinion on the merits, the judgment on the merits will be given, don't do anything to destroy those embryo steps so that they are stored in proper conditions. So this happened for the first time ever. However, on the negative side, we have to take a look at the case against SH and others in Austria, in which was brought in 2000 and the judgment was given 10 years afterwards. Much help did it do to the applicants, in the sense that 10 years in reproductive life is really a very long period. Also, the achievement is the fact that we had first violations ever of Article 3 in the context of reproductive rights in the Slovak cases and in PNS against Poland. And that recently, but this belongs to the discrimination area, there have been really solid judgments in discrimination cases with a very consistently applied principle that the burden of proof is on the defendant state. As to the challenges, the law in the area of bioethics, and especially medically assisted procreation, law lags behind technological developments, and it is not for the court to step in where the states did not decide to regulate. So the court is and would be very reluctant to say that as the court we tell the states to do this or that. I don't think it is likely to happen. Then this approach is slightly counterintuitive because we would tend to think that the states should regulate in order to comply with their positive obligations, which is not always the case because in practice, in many cases, lack of regulation can be more conducive to respect for respect of human rights than existence of restrictive regulation, especially in the area of medically assisted procreation. Another challenge for the court, but this is a general challenge applying to across the board to all cases, that in the last 3 conferences about the court future, Interlaken, Izmir and Brighton, there has been a huge stress on the subsidiarity, which is saying in other words that the court should watch its step and it should not become or continue to be interventionist. So probably the court takes it into consideration as well, trying to be more, I would say, circumspect. We have had also recently, in the last 3 weeks, a very strong political attacks on the court in the UK, including for the first time, the Minister of the Internal Affairs of the UK, Mrs. May, to say that the UK will consider withdrawing from the convention, which has never happened before, more or less, since the convention came into force, and that sort of determines the political context in which, or at least colors the political context in which the court is functioning. And then there might be a risk on the part of the court of trying to appease this criticism by becoming, as I said, more circumspect. Then the last thing on the challenges side would be that in reproductive rights cases, the court approach to the interpretation of the margin of appreciation is not particularly consistent. In ABC against Ireland, the court really was bending over backwards in order to say that even though we note that there is European consensus in the area of legal availability of abortion, say there was only at the time Poland, Malta, Portugal, and Ireland which made abortion practically illegal, but then the court said, but still there is a wide margin of appreciation in this area for the states, regardless of the existence of this consensus. So we have a problem here, and the same essentially happened in this case concerning SH and others against Austria. It is difficult to follow why consensus, the existence of European consensus, was found not to exist. The court said because the consensus was not based on settled and long-standing principles, and it only reflects a stage of development, in particularly dynamic field of law, which is a convoluted way of saying, okay, there is a consensus, but still we think that in reproductive rights area, the margin of appreciation of the state should be very wide, which does not bide well for the future of those cases, and makes medically assisted procreation cases particularly vulnerable to this interpretation. And the court in SH attached very serious weight to moral considerations of social acceptability in determining the case, and this was enough for the court to step back. And the curious thing was that the state said only in their submissions to the court that this sort of issues having to do with medically assisted procreation was giving rise to serious controversy in the society, without saying anything about what was the substance, what are the views, and what were those controversies, which means that the court didn't even have to listen to what kind of controversy they raised, and then it felt enough to step back and to say, okay, fine, broad margin of appreciation. So there is a little problem here, and I think that in the future we should expect that the medically assisted procreation cases, this margin of appreciation will be found to be quite broad. Okay, thank you. That's all I wanted to say, and I give the floor to next.